Good evening, ladies and gentlemen. It's a pleasure to welcome you to this evening's program. We do it our way, top tips from top female litigators. My name is Randy Supalik, and I'm the president of the Northern District of California's chapter of the Federal Bar Association. To those of you who are members of the Federal Bar, I'm glad to see you here. To those of you who are not yet members, please join. The Federal Bar is the preeminent legal organization for those of you who practice in federal court. Our chapter here in the Northern District is a very active one. We've had 13 programs so far this year, at least 1 or 2 programs a month. I'd like to highlight 3 of our remaining programs for the year. October 9th, here in this courtroom, we will have all of the new district court judges for the Northern District, including those from San Jose. November 10th, we will have a program investigating the executive. That will be with Judge Breyer, John Kecker, Greg Bernstein from Jack Davis's prosecution team, and Richard Benveniste from the Watergate prosecution team. December 3rd, we will have our annual class action program here in this courtroom. It's been an exciting year of programs, and I encourage you to join so that you can participate in all of them. At this time, I'll turn the program over to Judge Yvonne Gonzalez-Rogers. Thank you.
Thank you. Okay, well, welcome to the Northern District of California. This is our ceremonial courtroom where we do all of our fun things and fun programming. I'm so excited to moderate this panel and to help choose the trial lawyers who you're going to hear from today. What we're doing today is we're going to go through kind of the highlights of a trial. Voir dire, opening statements, a direct, a closing, a direct, a cross, and a closing. And I'm going to introduce each of the panelists as they come up and talk to you. So our first trial lawyer to highlight is Lynn Hermley. Lynn is a partner with Orrick and is, no, come on up. She's a partner with Orrick and has been doing employment law for quite a long time. One of the things that I'm hoping that you'll be able to see is we've picked people from lots of different areas, and hopefully there's something about their story that resonates with you so that you can see yourself doing what they do. Lynn's being helped by 2 of our terrific FBA members, Elise LaRouche and Molly Preden. But I want to tell you a couple of things about Lynn before she gets started. So even though she's at this big firm, and that might seem a little bit off-putting to some people, Lynn is actually this really down-to-earth person. I would say, having talked to her and read some things about her, she was probably, it sounded like she was raised by an incredible single mom.
It's true.
And she waitressed for a long time. People thought, or she felt like she was a little bit anxious, so she's learned, and you cannot tell that as in her trial presentations, but so she learned to deal with that. And that's just one of the things that she can help talk to you about as she explains how to connect with people during voir dire. Lynn.
Great, thank you, Judge. So I believe cases are won and lost in voir dire, and even though that's true, many great trial lawyers are not very good at voir dire. So it's a part of the case I spend a lot of time preparing for. What we're going to do is some actual voir dire from a case I tried in 2015, and I know there are a couple people in the audience that I remember seeing in that trial. It was Powell versus Kleiner Perkins. And so we're going to go through the actual voir dire that I did with this juror. Background is Judge, can I just fix my mic? We're so good? How about that? How about that? How about that? Okay. How about this? Okay. Okay, I'm not losing time, am I, Judge? Hello. There we go. Thanks so much, Elise. All right. So the background is Judge Kahn has granted 9 cause challenges that I have made, and he's not very happy about that. And the judge over here, Judge Kahn, Molly will be playing Judge Kahn, makes that clear.
So, Ms. Swift, you spoke about
You're out again?
we're losing when I turn mine on. I can just. Yeah. Okay, I'll just turn it off. All right. Swift, you spoke earlier with Mr. Axelrod about a dispute with you described him as a sexist or an ageist supervisor, which sounds like it led to your resignation from that job. Is that correct?
Yes.
And can you tell me a little bit about that, please?
I felt the supervisor discriminated against older employees and women, and specifically against me.
And I'm sure that was a terrible experience for you.
It wasn't pleasant, but I don't have nightmares every night, but
How long ago was that, Ms. Swift?
it was about 7 years ago.
And do you still have any feelings about that experience?
Well, it was a bit of a strange situation because I actually ended up working for him again. So it wasn't cut and dry, there was nuance.
And nuance in what sense?
Well, because I quit because of him, and yet I still went on to work for him at another place, so
Well, that was unusual.
yeah, very.
So is there anything about that experience that lingers with you in a way that might impact your views in a case which involves someone claiming employment discrimination?
I mean, like we said, it was unusual. It's not something I experienced elsewhere.
Well, I'm asking you about this because I get the sense, including from your questionnaire, that you might be unsure about whether you could put that experience aside if you sit as a juror in this case.
I haven't forgotten about it, but I don't think it has any bearing on this case.
Do you have any uncertainty about that?
Maybe.
As you sit here today, do you think that a plaintiff who's claiming discrimination might be just a bit ahead with you, given that experience?
Well, I also have the experience of knowing someone who made a false claim, and I think that was extremely unfair. And I went to my supervisor and reported it and prevented that claim from going through. So I've been on both sides before.
So I'm going to ask you to answer Ms. Hermley's question. If you don't have it in mind, I can repeat it if you want. The question was specifically, do your past experiences lead you to give Ms. Powell a little bit of the lead if we analogize this to a foot race?
Well, I don't know what all the criteria is in the civil case, but it might lead me to give her the benefit of the doubt.
So one of the criteria is you can't give anyone the benefit of the doubt. You treat every witness, every party on the exact same terms. There's nobody who starts ahead, there's nobody who starts behind. So do you believe you would, and I really appreciate your candor because this, as I said, this is a process that doesn't work unless people are candid. Do you believe that you could give Ms. Powell, do you believe you would give Ms. Powell the benefit of the doubt?
Well, I would try not to, but I can't say 100% that I wouldn't.
So this is where
get into the commitment. Right now, what is your view? Do you think it's more likely that you're going to be able to set aside your past experiences, or do you think you're really going to have trouble doing that?
Well, I don't think my past experience is going to be, I don't know, I don't remember the specifics of the case, but I don't think it's going to be the same. I doubt that it would be.
There's almost certainly no case ever going to be the same as any other case. But the question is really whether you think you're going to be able to use your experience as a frame of reference for this case, or if you can set that aside and consider this case on its own.
I would try to set it aside.
So at any particular time, if you weren't able to do that, you commit to letting me know immediately, right? Yeah.
Yes.
But right now, you believe you can set it aside.
Yeah, I've been trained to be objective in my line of work, and so it's important to not let my personal feelings get in the way.
So I think the test for
you, Ms. Swift, but in my mind, there's a difference between trying to do something and being able to do it. Right now, do you believe there may be some issues with you being?
Hard for me to know without knowing all the facts, but I would try to evaluate the evidence from that and not what happened to me, if that's the question.
Not all jurors are perfectly suited for this kind of case. Do you think this might be the kind of case that you're not perfectly suited to because you can't be completely impartial?
I mean, that could be, since I have a personal experience.
Thank you so much, Ms. Swift. We really appreciate your candor. So that's what led to the cause challenge. And it was the 10th of the case. I think we went on to have 14. Helen, what's your 4? Okay. So a couple thoughts I have about voir dire. First of all, it is really something that you have to plan for. And I'm always surprised when I see an opponent who comes in with little planning or little thought. In my mind, you're doing two things. You're giving information and you're getting information. The second is obviously more important because what you're trying to do is not find the jurors you want, but you're trying to find the jurors who will not be fair to you and exercise ideally a cause challenge, leaving you with your peremptories. Or if you're not able to do that, one of your peremptory challenges. There's one thing I forgot to do in this demo here because I was going to ask Elise about teamwork, which is something in this trial I put often in my voir dire questions. I'd ask people about whether teamwork was important in their workplace and why it was important. It was just one of the themes that I was placing out there. I thought the jurors would pick up on it, and in fact they did. I typically try and connect well with the juror. The most important thing is for me to create a space in which they're free to say they may have issues that cause them not to be fair in this case. I know I start behind generally as an employment defense lawyer because the science shows something like 63% of jurors believe that employers have issues that are at stake in litigation. So I try very hard to connect with the juror. I try hard to have my questions be somewhat gentle and to create a space for that to come out. I do think it's really important that you plan ahead your note-taking system. I've never found a great one. I rely on the Harry Old thing that we used to do back in the early 80s. I take a big file folder. I create a sticky for each juror. I write notes on the sticky. When the juror's excused, I place it in another part of the file. You really have to keep those notes because you might get a Batson challenge or some other challenge and you may want to read from it. So that's what I do. I hope it was helpful. And with that, we're moving on. I think you're over.
I think so.
Great.
Thank you. We will have all of them come up and give you some additional thoughts, but we do want to take each piece of the trial. Next we have Karen Dunn, who's going to give you her opening. Karen does both civil and has done criminal trials. She was an AUSA on the East Coast. We like to have her on the West Coast, the best coast, as my daughter says. She is now named partner in her own firm, Dunn, Isaacson, and Ree. Okay, brand new firm. What's interesting, I think, about Karen is that, yeah, she, had that traditional thing of clerking for Justice Garland and Justice Breyer, that kind of career, but she was communications director for Hillary Clinton when she was in the Senate and press secretary during her campaign. In addition, she apparently has this hobby of prepping candidates for presidential debates. Obama, Hillary, Harris. I think one of the things that I find most interesting about her career and her success as a trial lawyer is that she's communicating, right? This is a human endeavor, and she's learned to communicate. So think about how it is you all have learned to communicate with people. Karen.
Thanks, Judge, for the very kind introduction. I've been fortunate to try not one, but 2 cases in front of Judge Gonzalez-Rogers, and both were fantastic experiences. I decided to give the opening, I'm going to give an 8-minute segment of an opening, not from one of those cases, but instead I chose a case where I, along with others, sued 24 groups and individuals responsible for the violence in Charlottesville, Virginia on August 11th and 12th of 2017. So there's a little warning that some of the images that you'll see are a little graphic, not necessarily more graphic than anything you would see on TV these days, but I think it's appropriate to warn you. And I'm also going to do the part of the opening that I did exactly, or more or less exactly, how I did it in the actual case. Ladies and gentlemen, this is a case about racially motivated violence and intimidation that the evidence will show was planned for months in advance and culminated on August 11th and 12th of 2017, right here in Charlottesville, Virginia. We're going to show you some of our evidence, and I want to warn you that some of it may be graphic or contain disturbing images. Oh. By the way, this is also what happened in real life. Hold on. Oops. Yeah, can you play that would be great. Keep going. On August 11th of 2017, hundreds of white nationalists from across the country came to Charlottesville. As you will hear, they met up in darkness on UVA's college campus. They carried torches and they chanted, "You will not replace us." Then, "Jews will not replace us." Then, "Blood and soil," a phrase that you will learn originated in Nazi Germany. From there, they climbed the steps of the UVA rotunda, and they descended upon 20 to 30 unarmed, peaceful counter-protesters, most of whom were students at UVA, who had gathered around the base of the Thomas Jefferson statue and linked their arms. The evidence in this case will show that the white nationalists encircled the counter-protesters over 10 people deep. They maced and physically attacked the counter-protesters. They screamed racial slurs. Then they threw unidentified liquid on them while wielding lit tiki torches. And you will hear in this case how after the violence, Richard Spencer, the most prominent white nationalist leader in the country, and one of the defendants in this case, climbed up onto the statue and declared victory. The evidence will show that the next morning, Richard Spencer emailed his followers, declaring that what happened at the Torch March on August 11th was, quote, "only the prequel." And you will come to learn that he was right about that. The defendants in this case knew that there was much more to come because their plans had secretly been in the works for months. The evidence will show that the next morning, August 12th, the white nationalists came prepared to commit violence. They wore riot gear. They marched in formation. They carried shields and flagpoles that were later used as weapons. And then, at approximately 1:41 p.m. on August 12th, this happened. Defendant James Alex Fields, who had marched that day with another defendant, Vanguard America, wearing the Vanguard America uniform and the Vanguard America shield, got into his Dodge Challenger and intentionally drove it into a group of peaceful counter-protesters, killing a 32-year-old woman named Heather Heyer and injuring many others, including many of our plaintiffs. Next slide. My name is Karen Dunn, and along with the team of lawyers who joined me at council table, it is our privilege to represent the 9 people who were victims of the violence from August 11th and 12th. People like Marcus Martin. The evidence will show that Marcus's leg and ankle were shattered when he pushed his fiancée out of the way of the car. He will tell you that while the injuries he faces that are physical may heal, his emotional injuries likely will not. People like Natalie Romero. Natalie's first generation college and her family. She had just returned to campus after her very first year at UVA when she was struck by Fields' car. The impact fractured her skull, lacerated her face, and forever changed her life. She will tell you that every day she has to wake up and look at the scars on her face. It is a constant reminder of a nightmare that she wishes she could forget. Now, in a short while, we will introduce you to all of the plaintiffs, all of whom are in court with us today. And even though it will be extremely difficult for them to relive the events of that weekend, they are going to come tell their stories directly to you. Because for them, they believe that it's important that the truth of what happened in Charlottesville be told. And so while this is a case of violence and intimidation, the plaintiffs will tell you that for them, it is also about justice and accountability. Accountability for those who planned and perpetrated the violence, thinking that they would get away with it. On behalf of these 9 plaintiffs, we want you to know how grateful we are for the time that you are taking to be here with us, taking away from your families and your work and your jobs. But your job here is so important. You, the jury, are the fact finders of this case. And after you have seen all the evidence, these 9 plaintiffs are going to ask you to hold the defendants accountable. In a trial, it's the job of the judge to instruct the jury on the law. Judge Moon is going to instruct you about when a conspiracy to commit violence motivated by racial hostility violates the law. And your job as the jury will be to apply the law as Judge Moon instructs to the evidence in this case. And we are going to show you a lot of evidence. Like this text exchange between defendant Chris Cantwell and defendant Richard Spencer from August 7th, just 4 days before the violence in Charlottesville. Mr. Cantwell says, "I'm willing to risk a lot for our cause, including violence and incarceration. I want to coordinate and make sure it's worth it to our cause." And Mr. Spencer responds, "It's worth it, at least for me." The defendants' own communications with each other will show that the violence of August 11th and 12th was no accident, that the defendants planned for violence, they executed violence, and then they celebrated the violence after the fact. Now, before we introduce the defendants to you, there's one important thing I want to say at the outset, which is that the plaintiffs in this case did not sue the hundreds of people who came to Charlottesville to march, to speak out about their white nationalist views, or to have a rally. We want to stress that there's absolutely nothing wrong with that. Everyone is entitled to their beliefs, no matter who they are. The plaintiffs firmly believe in the First Amendment, and in fact, the evidence will show that many of the plaintiffs themselves attended the events of August 11th and 12th to exercise their First Amendment free speech rights. So the plaintiffs in this case only sued the leaders and organizers who planned the violence and the most violent foot soldiers who carried them out. The defendants may want to focus this case on politics, but this case is not about that. This case is about the planning, execution, and celebration of racially motivated violence. The evidence will show in this case that many of the defendants are key players in a growing white nationalist movement who believed that their time had come. They want to build a white ethno-state in North America, and that can only occur in their minds after a violent race war. They wanted to build an army of white nationalists for what they themselves called the Battle of Charlottesville. Okay, so Judge asked us to have some takeaways from what we did, and the first takeaway I would say is that I never introduced myself right off the bat, because I think when you first can talk to jurors or probably judges, they're really engaged right at the beginning, and you want to make sure that you tell them what the case is about, what the narrative is, and what the story is going to be right away. And I think if I spend time saying, I'm Karen Dunn, and it's such a privilege to represent this company or this individual or these plaintiffs, it just wastes a lot of time, and I can get to that later. So that's thing one. The second thing is, when you have evidence that is powerful, and obviously this case is a little bit of an aberration, but I do think it's important to front the most powerful, evocative evidence and to explain to the jury why it matters so they don't feel like you're just trying to whip up their emotions, but you're explaining it to them as part of the story. And then my last takeaway is, as you can see what I did at the end, I wanted to diffuse the First Amendment arguments from the defendants, and I wanted to diffuse the arguments that this is just all about politics from the defendants. We were in the Western District of Virginia, very, very rough jury pool, and so I thought it was important just to confront these things right at the beginning and explain to people what the case was really about, which is how we portrayed those events as being about the violence that occurred.
Thanks, Karen.
Thanks.
Next up, we have Doris Cheng, who is being assisted by Dr. Christian Yagush. Doris practices plaintiff's litigation, and she has since she left law school. She is a partner with Wallop, Melodia, Kelly, and Schoenberger. Doris is a daughter of Chinese immigrants who came here from San Francisco. Her mom cleaned homes and her dad worked in the kitchen and in a kitchen restaurant. And Doris tells the story that she did all the talking for her parents because English was not their first language. So when she got into the courtroom, she felt like she was home because what was she doing? She was talking to people. She was communicating with people and telling stories. Doris.
Thank you. Well, we're going to do a bit of a direct examination of an expert, and a couple of the takeaways I would say when doing direct examinations of experts in particular. Number one, let's try to make them likable. Number two, let's try to have the jury learn something by the end of the examination. And we thought it would be fun here to do one, because Dr. Yagush is available. He's actually an attorney in my office, but he is a genuine emergency room physician with 16 years of experience as an emergency room physician before deciding to go to law school. So that's a little spoiler alert, though he still is a practicing emergency room physician moonlighting. So this is the case of a 23-year-old college student who had signs and symptoms of a stroke, went to UC Davis, where they should have initiated the stroke protocol, but they didn't, assuming that because he's only 23 years old, he couldn't be having a stroke and he was probably doing drugs. And 26 hours later, when they did find the stroke, 3/4 of the left side of his brain was blown out. And so he is no longer able to function meaningfully in terms of being able to work or communicate. He has lost his speech, meaning the part of his brain that develops or that deals with language, the words are in his mind, but they don't get to his lips. And he can't text or type because, again, the words that are in that part of the brain, they don't translate. The signals are no longer moving to his fingertips. So we have the emergency room expert. We have, and I'm just going to step down actually because I think another part of just good advocacy is that I'm not on top of the witness. Right? This is my direct examination. And if I do a good job, hopefully he's teaching you all something. And I have a clicker, right? And just in the short amount of time that we have, a brief introduction about him, and let's learn about strokes. So, Dr. Christian Jagusz, tell us, what is your profession?
I'm an emergency room physician.
Tell us, where did you do your training for emergency medicine?
I trained at LAC USC in Los Angeles. It's a 4-year emergency medicine program, actually the oldest in the country. And at that program, I was the top resident in my senior class.
What is the specialty of emergency medicine?
Emergency medicine, a lot of people think are doctors that just do a little bit of everything. We're specialists in resuscitation. We're specialists in emergencies like stroke, heart attacks, gunshot wounds. So if you need cataract surgery, you don't come to me. But if you have an emergency, something that's life-threatening, that's where you go to the emergency department to be seen by an emergency medicine specialist.
How long have you been practicing emergency medicine?
I finished my residency in 2001 and have been in practice since.
In fact, in 2001, when you were a resident at USC, what was the USC ranking in the state of California?
We were in the state of California, we were the #1 residency program, not only in the state of California, but nationally.
And when you were trained in your residency, what were you trained as far as strokes? And I want to focus a bit on strokes here. What was the training with respect to strokes?
Sure, strokes is one of those emergency medicine, we'll call it sort of staple of the training program, because in stroke treatment, time lost is brain lost. So you have a very narrow window to identify the problem, to treat the problem, and hopefully make the patient better.
And let's talk about what is a stroke. Can you describe that for members of the jury?
Yeah, that's a great question. You think about strokes in 2 forms, and I'm going to sort of shortcut one form because it doesn't really apply here in the case of Mr. Bieber. They're what are called bloody strokes. Okay, those are when people have a hemorrhage. They're also called embolic strokes. Now, most strokes are embolic, which means there's a blood clot, typically that moves from one part of the body up through the heart into the brain, which causes a blockage of that artery. So think about heart attacks, so where there's a blockage of an artery to the heart. This is a blockage of the artery in the brain. I believe we have some picture that might demonstrate my testimony.
Okay, and in fact, would a diagram of the brain and the vessels assist your testimony?
It would definitely help me explain to the jury what went on, especially in Mr. Bieber's case.
Okay, and Your Honor, may I have the witness step down to the diagram?
You may.
And Dr. Jagusz, I think just for purposes of, let's use the diagram over there on the other side. Okay, tell us, what does this diagram depict?
So this diagram is created from the actual imaging of Mr. Bieber. So when he arrived at UC Davis, he initially received a CT scan, later received an MRI that showed the blood vessel. So this, unfortunately, in this case, is what happened 26 hours later when they missed the stroke diagnosis.
But just so that we understand vessels and what you call an embolic blood clot, embolic stroke. First of all, on the left side where it says anterior sectional view, is that just a diagram of the skull with the brain?
Yeah, so if you can imagine the way these images are created is the skull is The image is created this way, so you're basically looking at a cross-section from the frontal perspective, right? So you're looking straight forward as if I'm sitting here looking at you.
And then describe what are those vessels that, blood vessels that are depicted on that diagram?
Right, so there are basically three major blood vessels that supply what we call the anterior, the first part of your brain, which is the anterior cerebral artery, the middle cerebral artery, which is demonstrated here, which has branches, and then the posterior cerebral artery, and that's what supplies blood flow to your cerebrum.
And anterior refers to sort of the front of our head and posterior to the back, is that correct?
Correct. So you've got, again, looking at anatomically, anterior, posterior, and then you've got it as those branches come out laterally.
And the pictures of can you just point to us where the vessels are, the medial MCA, what you call the middle cerebral arteries?
Right, so you see how they come up from below, they then branch, and what we see here specifically was isolated was the middle cerebral artery, because that's what was affected in Mr. Bieber's case, and that's actually what's affected in most embolic strokes that people have.
And when you say embolic stroke, you're talking about the clot. What happens when there's a blood clot in one of those cerebral arteries?
Right, so what we see here, the blood clot is actually demonstrated as this red, very dark red structure, and if we had a bigger screen, we could blow that up. The blood, in this case, we understand that the blood clot actually moved, and so that's actually why you see this. But you can imagine if this is just a hose, right, and the hose is applying blood to the brain. If you kink the hose, what happens, right? You get no blood flow past that, and that's exactly what happened in Mr. Bieber's case. All of this black area, or dark red area, is what we call infarction, right? So it's an area where the brain no longer has blood supply, and that area dies.
And in fact, infarction refers to the area where the brain cells have died. Is that correct?
When an infarction is complete, yes. But what's important to remember, particularly in this case, is there's a certain time window where you have salvageable brain. And that's why time lost is brain lost when it comes to strokes, because even though this hose is kinked, if you can unkink that hose, that brain tissue can live. And that's what didn't happen to Mr. Bieber.
Okay, could you please take a seat, Doctor? We have 2 minutes, and I want to actually talk for a moment about the stroke protocols. First of all, what is the standard for diagnosing and treating a suspected stroke?
It's a great question. The treatment and pathways for the treatment of acute stroke are standardized across the nation. And they're standardized through the American Heart Association, which creates guidelines, which then gets translated into what we see here, which is the UC Davis stroke protocol. So in this case, the standard of care reflects the stroke protocol, which, again, no matter where you go in the country, this should be the same.
Okay. And actually, when you say it's a national standard, how does a standard like this become national for all emergency room physicians?
In the case of stroke centers, they're certified, saying that we've adopted these policies, procedures, and protocols based on the national standards, which are published by the American Heart Association primarily. And then once they've certified that they've done that, then benchmarks are monitored to be sure that they're holding up to the benchmarks to retain their certification.
So let's just stop there because we're out of time. But I hope you did learn something about strokes, that there are two different kinds, right? That's going to be your takeaway. And I think critically what became our theme in the case is that time is brain. And that's something that all emergency room doctors are trained on. And I think just a couple of, how do I go back? Okay, so I'll just give you a couple of takeaways, I would say, when we're doing the direct examinations. Like one of the things that I wanted to try to do here was at least tailor the credentials to stroke, something that he sees all the time, because we want to bolster his credibility. Number two, have a clear opinion question, and didn't get quite to the, do you have an opinion as to whether there was a breach of the standard of care in the care and treatment of Matthew Beaver when he presented at UC Davis on the date in question. But we need one of those because there can't be any ambiguity, right? Especially in a medical malpractice case, it's about the negligence, and I need expert testimony. That's case law. So know that, what your criteria are, and make sure that you have a clear opinion question. Whatever that opinion is, it's a causation or whether it's a standard of care issue. And that's true no matter what type of case we're doing, right? So there are cases where we have product liability cases, auto product liability cases, where the question is, what was the cause of death? What was the defect in the vehicle? What was the defect in, fill in the blank? Do you have an opinion to a degree of, scientific probability? So clear opinion questions. I tried to define terms because he gets excited about saying words like embolic and infarction, and then I have to slow him down. He gets excited about words like anterior and posterior, so slow him down. And then we need to use an exhibit, so he's teaching. He did a great job of, the example of a hose, and using analogies as much as we can. I wanted to throw in a hypothetical, we didn't quite get in there, but it's a helpful type of tool to ask questions and get your expert to explain everything having to do with, the facts of your case, but in the setting of a hypothetical where he can, as I said, get kind of right to it. So those are kind of my takeaways, and thank you for letting us use the time.
Absolutely. Thank you. Next up, we have Darylyn Dury, who's one of the most preeminent patent litigators, certainly in the Bay Area and nationally. She is now a partner at Morrison Forster. She's being helped by my able law clerk, Samantha Yee. But interesting, people described Darylyn as professorial, as a teacher, and interestingly or not, she was a comparative lit grad student. How one gets from comparative lit to patent law, what she would say is that, it's about telling stories, right? And hopefully justice prevails in the end. The other interesting thing that I learned recently, other than we were summer associates together a very long time ago, is she's taken up motorcycles. And when I asked her about that, she said, well, you're on motorcycles with someone else, something in common, you just talk, right? We're talking again, communicating to jurors. Darylyn, take it away.
Great, thank you. So I'm going to start with hinting of the cross-examination of a technical expert in a patent case. This is slightly condensed, but basically just taken from the transcript. Now, Dr. Barron, we've known each other before, looking out. Yes. And you were asked by Novartis to render an opinion about whether the classic non-patents are valid or not.
Correct?
Yes.
You
did not go into your lab and perform any experiments in the course of coming up
with your opinions, right?
That is correct.
Now,
Do you think the examiner at the United States Patent and Trademark Office made a mistake in allowing the claims
of the 640 patent to issue, correct?
when one doesn't have all the information in their hands, then that is an issue. I should also mention that maybe for the benefit of everybody, patents are not divinely ordained and they're subject to human error. Thank you, Your Honor. I propose to read the witness deposition, page 117, lines 12 through 15.
Proceed.
Now, Dr. Barron, I took your deposition, right? Yes. And you prepared for that deposition? Sure. And you tried to give me your best testimony at the time? Yes. Right? From your deposition, page 117, line 12. Question. But I just want to be clear, your opinion is that the examiner made a mistake in allowing the claims of the 640 patent to be issued. The answer, yes. That was your testimony, right? Yes. You would agree that the patent examiner probably knows more about patent law than you.
Sure.
Okay. So that was basically just the beginning.
The takeaway is you've got to start by deciding who the expert is and the grounds on which you're going to engage with him. This was a very, very skilled technical witness. I wasn't going to get anywhere boxing with him on chemistry, but I could put a frame around his testimony and get the jury maybe to start doubting his credibility from the beginning of the cross-examination. So in thinking about, can you advance the slide? It's not advancing. Thanks. So in thinking about cross-examination, I like to start with what's the goal of the examination. How do I want the jury to think about this witness? So one example might be the witness is a good expert, but was fed bad information by the lawyers. I don't have to take on the expert's credentials. Maybe the frame I want is the witness has admitted some key facts that are important for my case. Maybe the frame is the witness is a liar. I mean, sometimes that is the takeaway. Or maybe the frame is the witness doesn't actually know anything that's relevant to the case, so you can just forget about him and ignore his testimony. But I want to be very clear when I'm preparing my cross-examination what I want the high-level takeaway to be. And I think about it as when the jury goes into the deliberation room and they talk about that witness, what's the headline comment that I want the jurors on my side to say? Can you advance to the next slide? Nope. Thanks. So then I think about what do I have that I'm going to be able to use as control in that cross-examination. That might be deposition testimony, whether from this case or from another case. It might be documents from the case. But it also might be things like articles, course materials. A lot of experts also teach classes. Their course materials may be available online. YouTube videos, things that they posted on LinkedIn. I try to think very broadly about where they may have said things that could be useful. But other forms of control are just things like logic, which sometimes is the best form of control, or what the witness isn't going to know, if part of what you are doing is trying to cabin the scope of their relevance to the case. Can you go to the next slide? There. Next, I want to think about what are the key takeaways? What are the key takeaways from the cross-examination going to be? And it should be a small number. So usually I want to make a handful of key points, 5 to 7, 20. I usually want those points to land in real time. So I try to do enough setup that the jury will be following along. I think cross-examination ideally should be interesting, right? And I try to set it up so that they will understand the points in real time. Critical thing to keep in mind, are you going to be allowed to use the transcript in closing? Having grown up in ND Cal, I thought the answer to that question was always yes. I learned it isn't. In some jurisdictions, you are not allowed to. And if you are not allowed to, it is all the more critical that those points land in real time during the cross-examination itself, because you won't have the benefit of the transcript to use in closing. And finally, as one of my favorite characters from The Wire said, if you're going to shoot the king, you better not miss, right? We as lawyers love cross-examination because we think of it as the lawyer's art. One of the most informative programs I went to was an ABTL mock trial presentation where we had a jury of lawyers and judges and a jury of jurors, each of whom were providing real-time feedback. As soon as we got to the and they mostly correlated. We could see it on screen in real time. Mostly it correlated. And you could see one line for each of the two sort of mock juries. The one place where it dramatically diverged was when the cross-examination got juicy. The lawyers and the judges loved it. The jurors, not so much. And it was very instructive that if you are going to take someone on, you've really got to win the exchange, and the jury has to be on your side, or it's going to backfire.
That
wound up accusing me later in the examination of gaslighting him. That went well. But I had to work up. I mean, it took a while to work up to a point where he was going to get that agitated that he then accused me of gaslighting him. And in terms of key techniques, I really like using graphics. I am super neurotic about my control and making sure that if I'm going to ask a question from the deposition, it's going to be exactly that. I really have to know your lines. I try to almost memorize the questions so that I will have notes, but I can engage with the witness. I have seen lawyers, I don't do this, have all of their control in a red binder, and every time the witness deviates, you pull out the red binder, and it becomes this sort of Pavlovian reflex relative to the red binder. I like to put on a bit of a show, because I can't help myself. And time management is critical in cross-examination, as in all things. Final closing thought, I just thought I would show you what my cross outlines look like. I have two columns. I have the question I'm going to ask on the left. I have the control on the right in my outline. Maybe it's deposition testimony. Maybe it's a document highlighted so that my document, the person who's showing stuff will be able to find it. But it means I don't have to flip around. I have everything I need to do the cross sitting right in front of me. Thank you very much.
Great, thanks so much, Darylyn. And for our closing, we have Candace Mitchell with us. Candace has done exclusively criminal law. She is the first assistant in the Federal Public Defender's Office here in the Northern District of California. After college, Candace went and did Teach for America. Loves teaching. She teaches now. She fundamentally just wants to help people. And so again, when she thinks about her closing, she thinks about how it is that she can talk to people and communicate with them. Candace.
Hi, everybody. All right, so I'm going to do a closing from one of my cases. It's going to be abbreviated. You're not going to get to see all the fun videos. Imagine any part you don't hear me talking about extensively. I'm using the most wonderfully persuasive and engaging language. Because absolutely, that's totally what happened when I did this closing. There was never any fumbling. There was never any playing around. My language was eloquent. You just don't get to hear all of it this time because time. Okay, so let's see. Okay. On August 16th, 2023, Pedro Morales did not possess a gun. The evidence you've heard in this case was, as we told you it would be it filled with assumptions, expectations, and misperceptions. Now, before I talk about the facts of the case, I want to just take a brief pause and get into a little bit of some of the legal issues that we're going to have to deal with. One of the ones you are going to have to confront as you look at the evidence of this case is this idea of what the presumption of innocence is. Now, when you walked into this case and you walked into the courtroom, you looked at Mr. Juarez sitting here at the table, you might have said, I wonder what he did. If you thought that, that's not the presumption of innocence. What the presumption of innocence is that same feeling you would have if instead of seeing Mr. Juarez sitting here, you saw your brother, your partner, your friend. And it would be that feeling you would have to look at the government and say, I know this person. They could not have done what you said they did. You are going to have to convince me that they are guilty of this. That is the feeling you need to have within yourself as you go back and evaluate the evidence in this case. That is the presumption of innocence. Because what the government has to do in this case is prove every single element of this case beyond a reasonable doubt. And this case is full of doubt. Because the evidence you have heard and the evidence that they have presented to you falls far short of that meeting that burden. Instead, this is a case full of holes and inconsistencies. Now, when you think about doubt, and it's a doubt based on reason, and it's a doubt based on a lack of evidence, I want you to think about what you've heard in this case and what you've seen in this case. Because when it applies to Mr. Juarez, he is not guilty. And that doubt is based off of all of the evidence that the government hasn't been able to present to you and what you've actually heard. Conflicting statements from witnesses, physical evidence that doesn't support the testimony. Instead, we have a case where assumptions, misperceptions, and expectations were misused in this case. And that's how you could only return a verdict of not guilty. We're going to turn first to some assumptions. Now, in this case, we heard the 911 call of Ms. Hernandez. And what she said was, he brought me here at gunpoint. He has a gun. That was what she said in the 911 call. But when we actually had her here on the stand, when she swore under oath that she was going to tell the truth, what did she say? I never saw a gun that day. In fact, what she said was, the last time I saw him with a gun was approximately June 2022, a year ago. That 911 call means absolutely nothing. She didn't see a gun that day. She didn't see a gun at all. Those statements that she made were statements that she was making an assumption. She assumed that Mr. Juarez had a gun that day. She didn't see it. She didn't know. Now, when officers responded to Oakdale Avenue, when officers responded to the address that they believed Mr. Juarez lived at, they were coming with expectations. They had heard the 911 call and had thought that they were going to see him with a gun. That was where the expectations started to come into play. And they expected to find certain types of evidence on a gun. Forensic evidence, fingerprints, DNA. They found neither. Now, this is an optical illusion, right? If you look at this illusion, you may say, I see a rabbit. You may say, I see a duck. If you go into this, looking at this and say, I see a rabbit, that's what I'm expecting to see. But in fact, this is an image of a duck. This is where your expectations start to color how you see everything else. Because in this case, the officers responded to Oakdale Avenue thinking they were going to see a rabbit. But instead, this is a case about a duck. And because they went there thinking they were going to see a rabbit, they never considered the duck that was right there in front of them. Now, going back briefly to the forensic evidence that I talked about, we heard from a forensic DNA expert. What did she say? There was no DNA on the gun. In fact, Mr. Juarez was excluded from being a contributor to the DNA that was found on the gun. And then we heard about the fingerprints on the gun. They looked at the gun, they did the examination, and what did we hear? Mr. Juarez's fingerprints were not found on this gun. No DNA, no fingerprints. This was not a gun that Mr. Juarez ever touched. This gun that was recovered from the scene was not Mr. Juarez's gun. Now, let's talk about the misperceptions in this case. The misperceptions from the San Francisco police officers who had gone in expecting to see that Mr. Juarez had a gun and gone in with that assumption based off of what they heard in the 911 call. Now, there are some things that the officers can agree upon. Now, the officers who gave chase to Mr. Juarez in order were Officers Moran, then Officer Anderson, Griffin, Leong, Archia, and Elseth. Officer Leong didn't testify here, so we don't know what he actually saw and what he heard that day. And then Officers Griffin, Leong, Archia, and Elseth all said they never saw a gun. So we're focusing mostly on what we heard from Officer Moran and Officer Anderson. Those were the first two officers before the door, and those are the officers whose body-worn camera we relied upon in this case. Now, imagine you were watching the body-worn camera. All right, what we heard from Officer Moran and Officer Anderson as they went through the door are they got out of their car. They saw Mr. Juarez there. He was sitting on the front stoop of his apartment building. He had a bottle of beer in his hand, and he was drinking beer with his friends. They got out of the car. They yelled police. They gave chase to him. He ran in the hallway, and they chased him down, and they said they saw a gun in his hand. But in the body-worn camera we watched, no one ever sees the gun in Mr. Juarez's hand. It's never seen at all in the body-worn camera. Instead, all we see are the officers running down the hallway and ducking down the halls. Instead, what we hear from Officer Moran when he testified was that he saw Mr. Juarez at the bottom of the steps with a gun in his hand. But this is different from what we heard from the testimony of Officer Anderson. Instead, Officer Anderson, in his prelim testimony, says, I saw Mr. Juarez with a gun in the middle of the stairwell. That's where I saw him with the gun, not at the bottom, but at the middle. And then here today when he testified, he said, I saw him with the gun at the top of the stairs. We have Officer Moran saying gun at the bottom of the stairwell, and then Officer Anderson in 2 different occasions saying that he saw Mr. Juarez with the gun in 2 different places. He could not have had the gun at all 3 of these locations. Because if we believe what Officer Moran says, it's when Mr. Juarez is at the bottom of the stairs that he turns, the gun hits the stairwell and falls to the ground. If the gun falls to the ground at the bottom of the stairwell, how could Officer Anderson have seen him with the gun either at the middle or at the top? And remember where the gun was found. It was found immediately at the bottom of the stairwell, not near the top. We also have testimony from the officers about what they could see as they were going down the hall. Officer Moran said he saw Mr. Juarez with the gun when he ducked behind this wall here. If that were the case, Officer Anderson could not have seen anything at all based off of his placement. This is Officer Moran's body-worn camera. Look at where he is when he said he could see Mr. Juarez. Look at where his body area had to be. This is impossible for him to have been able to see what he said he could see from this area and have Officer Anderson report the same. But instead, isn't it more likely that what these officers had seen was the bottle of beer that was in Mr. Juarez's hand as he fled from them? The bottle of beer that's captured on the body-worn camera, that's discarded here so recently that the liquid inside the bottle is splattered there on the concrete. That when the officers went by and took their photos later on of the scene, that the fizz from the bottle is still present in the pictures. Isn't it more likely that the expectations of the officers were that they would see a gun and not a bottle of beer? That is what happened in this case, ladies and gentlemen. Remember, we also heard from Officer Artia, who claims that he heard the metal from the gun hitting the ground. But that's impossible based off of his placement. The body-worn camera we see is of Officer Moran. He's the first through the door. Officer Artia is too far away to have ever heard anything hit the ground from where he was. He's 4 officers behind the first officer. There's no way Officer Artia could have ever heard the metal that he claims he heard when a gun was tossed on the ground. Instead, isn't it more likely that any one of these other individuals who resided in this courtyard, all of which we could see in the body-worn camera, could have been the person who dropped a gun in that courtyard that day? In fact, couldn't it have been that someone had walked in that courtyard, heard the commotion outside, feared the fact that the gun they had on them, that they shouldn't have had on them, perhaps when they were taking out the recycling, was going to lead to them getting in trouble? Hearing the officers yell, police decided to toss the gun right there on the ground. And maybe they're the person who walked into apartment D, where the door is open and the light is on, and decided to hide away, hoping that no one would come inside that room that day. Instead, in this case, Mr. Juarez is not guilty. It's the assumptions, presumptions, and misconceptions that has brought him here today, and the only verdict you can return in this case is not guilty.
So while Candace gives you her quick takeaways, I'm going to ask my law clerks to help me bring some chairs. Let's put them sideways facing the audience, and I'm going to ask our panelists to come up front so that they can chat with you for the 20 minutes that we have left, or 15 minutes. Right here's Tony, all together is good. And we'll get some more tips from them. And I need one more. Yeah, thanks. So your quick takeaways.
Quick takeaways, I would just say, I still get very anxious when I get ready to give a closing, so I normally have to stand someplace and just like exhale, deep breath, play it myself, throw back my shoulders, and be like, all right, let's do this, right? I have to give myself the little pep talk before I get ready to go. And it helps me focus a little bit, and even now I can always tell when I start to settle into what I'm actually speaking about, because at the beginning, I'm still like amped up and the adrenaline's going, and then as I get into it, I start to settle into it a little bit more, and I think that's when I really start connecting with the jurors. Another tip I learned way back when is that when you are trying to connect with jurors, the amount of eye contact you have with them is important. That the way I imagine making eye contact with jurors is imagining looking at them, walking up to them, shaking their hand, and walking away, and that is the imaginary proper amount of time to hold someone's eye contact. It's the amount of time it would take to do that, because that's essentially what you're trying to do when you're making the argument with them. It's, I'm talking to you and only you, and this is the part of the time when we are connecting together. Always, of course, in a closing, you want to acknowledge the other side's strongest points and try and dismantle them with your arguments, because you want your arguments to be the part that the jurors are talking about when they're going back and discussing your case. And remember to repeat any kind of that language that you want the jurors to use during closing. Obviously, I had a theme here that I was trying to carry over from my opening throughout the questions that I gave and into my closing, and I hope that the jurors kind of took away part of that and what they were doing in their deliberation. And the last little piece of advice I would give is just, we've got a lot of amazing attorneys in the district, so when they are doing things, sneak in and watch. I love to watch Shafi do almost everything that she does in her cases because she is such an amazing talent, and so anytime I get a chance to watch any of you do what you do, I love to do it because I can take away something great from whatever I learned.
Thanks, Candace. Why don't you come join? So we just have about 10 minutes here, and what I asked each of the panelists to think about, it is kind of, we'll go down the line and they can engage with each other, but to share with you a short story or a couple sentences of, you know, an obstacle that as women, they may have had to overcome, how they dealt with it, what kind of bias did they engage, or you know, what would you tell your younger self, what you know now? So what tip would you get? Let's start at the end, Karen?
Okay, well, the question of obstacles could take up a whole other set of 100 panels. And I'll say this, I don't know a single professional woman who does not have infinite stories of bias. Our profession still has a long way to go. Obviously, there's been a lot of progress, but I think, you know, anyone who's been talked over on a phone call, mistaken for somebody who was not supposed to be doing the job that we were actually doing. I mean, this stuff happens all the time. So, you know, I guess I tend to kind of go right at it, which anyone who knows me will not be surprised about. And I'll tell one story, which is I once found myself as one of 3 lead counsel in a case where there were 3 law firms. And the other 2 lead lawyers from each of the 2 other law firms were both 60-year-old men. And we had our first meeting together. And surprisingly, they only talked to each other. And so when the meeting was over, I pulled aside the one who I thought I could have a better rapport with. And I said, you know, we're not going to have meetings like this again, where you 2 just talk to each other. We're all equal here, and that's how this is going to go. And he said, okay. And after that, it was much better. And then the second piece of kind of confronting it is when you are, I am very short, obviously, when you are a short, young-looking woman who who works frequently with somebody who is male and older, even if they are your equal in what you are doing, people will not assume that. And so what I have also done is I have sensitized the people around me to this problem. And I have said sometimes to my partners, you know, when we go into this situation, it would be very helpful if you would make clear that we are equals in this situation, because I know you think that, and not to play into other people's biases. So everyone here is going to have dealt with this stuff differently. We all deal with it, but I tend to kind of address it so we can move past.
Carolyn.
Yeah, I will say, I never used to feel like gender was that salient for me in the courtroom. And I have felt it much more, I would say, in the last, decade, 12 years. Because I feel like women in the professional sphere is becoming a more politicized thing in some places. I try a lot of cases in the Eastern District of Texas, just by way of example. And I'm very conscious of the fact that, like, I could give off Hillary Clinton vibes if, I were not careful. So, well, no, I mean, it depends on where you are. I learned in voir dire in one case that Hillary Clinton and Nancy Pelosi were the two. One of the questions on the form was like, who do you most admire and who do you most not admire? And in the Eastern District of Texas, it was neck and neck between Nancy Pelosi and Hillary Clinton for whom they least admired. Jesus Christ actually came out on top for the person they most admired. But I now, one, try to channel church lady, but two, I try to get it out in voir dire and talk to people about it and just be explicit, because I don't want it lingering around. And if I'm worried, and I do, like I ride a motorcycle, I feel like there's a lot of different ways I have to connect with people, but I want to make sure that's not going to be an issue. And so if I'm especially if I'm in a jurisdiction like that, where voir dire is very wide-ranging. I'll just ask people, like, how do you feel about having, women as lawyers? And you can actually get sort of pretty candid responses, but I would much rather just get that out on the table.
So we're going to hop over to Doris.
This is terrible to say to a judge.
You don't have to.
Thank you, because I'm kind of fangirling, and I'm just going to say that the brilliance of the voir dire that you saw is weaving in the language of California law or of, the law on entirely impartial. If you can get that in and get that agreement, this juror's out. And I think that's just to highlight, like, it's tactical and it's knowing the law. And I have to say, with the opening statement, you saw this brilliant use of weaving in the exhibits and the pauses in between to tell the story. And I was truly mesmerized. And say that the cross-examination is what I've always struggled with in trial, and the eminently reasonable voice that Derlin has. I mean, I think particularly, like, for women, I had a trial in San Luis Obispo where my co-counsel grabbed me and said, "The old man in the white doesn't like you being so mean to this witness." And I was like, shit, it's 2018. And I'm like, I'm still dealing with that, but you are, and, the sort of very careful, measured way. And then, my God, like Candace's closing, that brilliant use of the picture of the rabbit and the duck, it was not just that she used it, it was so seamlessly woven in as an analogy for the way that people think. And I gotta say, I don't do criminal defense, but this is why I love watching criminal defense lawyers, is that discussion about the presumption of innocence and getting into the minds of the jurors without violating the golden rule, but saying, like, if this is how you're thinking about things. I mean, it's just such great oration. I'm just sitting here fangirling. I'm loving it. So thank you for letting me say that.
Glenn, right behind you. Glenn, you're next.
Okay. I have so many things I could say in light of all this. I want to say I agree with Darylyn that I've experienced recently stuff that I never experienced in my career. I mean, I was sitting in San Francisco Superior Court preparing to argue, I was prepared, I wasn't preparing. Getting ready to argue a major motion for a huge client in a very high profile case. And I'm feeling pretty good. And I'm sitting there on the bench outside and a woman came clacking up in high heels and sat down next to me and said, "You must be my court reporter." And no, I'm not, but thank you. One of the gifts I got preparing for this was the judge asked us to talk to your team about how they think about you in trial. And my team said things about me that I never expected, that I was cool, that I was surgical, that I was always calm. And I think of myself the complete opposite of that. So the thing I wanted to say about the introduction you gave is I realized about a decade ago that I do have an anxiety issue and I have to deal with it. So I would say to all of you trial lawyers, find something that works for you. I found a mental image of a place and a breathing that works for me. I'm only really nervous when I get up to do voir dire and about 2 minutes before my opening. That's it. But for those, I really needed something. And so find something, go to a class, do the Calm app, find something, because having that crystal clarity is really important when you're looking into the eyes of a juror on a key voir dire, or you're making your opening and you're trying to connect.
Candace.
See, well, I'll just do this one since it's already on. Okay, so, time and experience, but, so I'll go with this. I remember when I first started practicing that I practiced in the Southern District, and it was a very conservative jury base. It's a lot of retired military that are there, and so as a woman, I felt very much so like I had to wear a skirt suit because this is what the jurors would expect, and I had to do all these things to conform myself into the person that the jurors wanted me to be. I used to chemically straighten my hair because that would be more presentable than having my hair natural. And I realized after time went on and after I've been practicing for a longer time that trying to conform myself to an idea of what a juror would want would mean that I am not being my actualized full self. And if I'm not bringing my full self, then I don't know if the jurors could ever really connect with me because I am instead trying to pretend to be a person that I think the jurors would like. And it took having representation and seeing other people who looked like me, other people who were in roles like me to say, it's okay. I don't have to conform myself to this idea of what I think this person should be who is an attorney in front of other people. I can still bring in a little bit of myself into this role. I can bring in myself into how I do things. And while I may love and really appreciate seeing how some people are as trial attorneys, I may also realize like I can't be that kind of trial attorney. I would love to do what they do because they are so engaging and they're so wonderful with how they do it, but it's still not intrinsically who I am as a person. And I have come to realize that probably the jurors would then sense that there is something off and there's something not true about who I'm trying to be because I think that emulating this other person is going to get me somewhere. And so over the course of time, and it takes some time, I got to play around with a few things and say, this feels more like me, feels more like me, this feels more like me. Until I now, when I stand in front of the juror, natural hair and all, thank you, Ketanji Brown Jackson, for also being a very good representative of that, but I get to be a little more of my authentic self. And it may mean that I'm not as formal as some people when they present, and it may mean that I move around a little bit more than other people. But I think that when I bring more of my authentic self to the presentation, a polished version of it, but more of my authentic self to my presentation, I think the jurors connect with that. And I think that all in all, even though I had this idea that if I pretended to be more like this, it would be better for my clients, the closer I get to who I authentically am, I think actually is the better thing for my client in the end.
So we hope through this presentation that you've seen different styles, different approaches, different practices, all success, all success. And I think that a number of the the things that, you can easily take away is having confidence, but preparation, organization, visuals, knowing your case, and having a plan and having a story, and taking that through the trial. Please join me in congratulating and thanking this panel of incredible trial lawyers. I want to thank Randy Supalik, Elise LaRouche, Molly Friedman for all their organization. There is a reception outside. Happy to chat with you all out there. Thank you for coming.